Hello, everyone. I'm Rose Colasino, co-lead of Indivisible Illinois and the Voters' Rights and Protection Chair. Also the lead of the Vote by Mail Task Force, the group hosting this evening. We welcome you to the Indivisible Illinois Community Collaborative Vote by Mail Task Force event, Courts Matter, Illinois to Voting Rights and Protections. We are grateful to welcome David Melton and Judith Myers tonight to present on the subject matter. Courts at all levels have a significant impact on our daily lives, from our reproductive rights to voting rights and gun violence reform. We look forward to hearing from David and Judith. Before we go on, however, I ask for a moment of silence in support of those that have lost their lives in Highland Park, Uvalde, and Buffalo, and so many other locations, too many to name. Those injured, survivors, those facing the loss of loved ones, and all victims of gun violence, including in my home city of Chicago. We also demand justice for Jaylen Walker. We will take a moment of silence. Thank you. David and Judith will be introduced shortly by Sherry Sweeney and Sandra Baskin from the Vote by Mail Task Force team. Before we get started with that, however, I have just some brief remarks about Indivisible Illinois and then the Vote by Mail Task Force team. Indivisible Illinois is part of the locally led, people-powered Indivisible Project Network, a grassroots American movement founded in 2016 with thousands of chapters across the US in urban, suburban, and rural communities. Indivisible Illinois promotes an equity agenda. The Vote by Mail Task Force advocates for voters' rights and protection by making sure that all voters have a voice through federal, state, and local voting rights legislation. We advocate for vote by mail because studies show us that vote by mail increases turnout and decreases inequities. I have a link about how universal mail-in ballots can transform civic participation that we will drop in the chat. The Vote by Mail Task Force is one of 6 working groups that host these meetings on Wednesdays. The other groups include the Social Justice Alliance, the Rural Group, I'll Vote, Truth Brigade Illinois, and REI. Ed Spire, who manages the strategic arm of the Vote by Mail Task Force with me, will share our upcoming events in the chat that we think will both interest you and hopefully have an impact. Ed is also our Zoom director for tonight and will share hosting duties with me. Ed, if you could please introduce yourself.
Thanks, Rose. Hi, I'm Ed. I'm a member of Chicago's Northwest Suburban Organizing for Action, NWSOFA Indivisible. We're a large progressive group centered out in Palatine and the surrounding areas. We're co-sponsoring this session with Indivisible Illinois. We're pleased to work closely with Rose and Indivisible Illinois to develop and promote events such as these. We have a number of such events coming up. I'm going to place links to some of them in the chat. Please look them over. See which events you'd like to support. Thanks, Rose.
Helps to unmute. Thanks, Janice. I will put my name. Sorry, I'm listed as Indivisible Illinois, but let me just make a couple more remarks. We will go to introductions right now with Sherry introducing David and Sandra introducing Judith. David will then start the presentation. We ask that you please put questions in the chat so that we can cover them once David and Judith go through the thorough, complete information that they have available for you tonight. We have everybody, I just want to mention, except for the co-hosts, on mute so we can get through all of this great material. I now send it over to Sherry to start the introductions.
Thank you, Rose. Yeah, my name, like Rose said, is Sherry Sweeney, and I'm from Union County, and it's my pleasure to introduce David Melton. David Melton is a semi-retired attorney who graduated from the University of Wisconsin-Madison with an undergraduate degree in history in 1974 and from the University of Chicago Law School with a JD degree in 1977. He spent his initial 10 years in practice focusing mainly on commercial litigation before shifting his attention to intellectual property litigation, consisting mainly of patent and trade secret cases over the last 25 years of his career, which he spent at large Chicago and national law firms. He largely retired from the active practice of law in 2009, but remains active in bar associations and law reform efforts in the area of campaign finance reform and election law, civil liberties, including police oversight, federal courts, and intellectual property. He worked on a number of pro bono cases in those areas while in practice and continues to be active in these areas as a co-chair of the Chicago Council of Lawyers Civil Liberties Committee. He is also an active board member of Reform for Illinois, the Chicago Justice Project, and the Chicago chapter of the American Constitution Society, as well as a member of the Lynn Inn of Court. David is a resident of Evanston, where he lives with his wife, Nancy, and where they raise their 2 children. Welcome, David. Now I'll turn it over to Sandra.
Hi, everyone. My name is Sandra Baskin. I'm a proud member of the Vote by Mail Task Force. And I have the pleasure of introducing to you this evening, Judy Myers, who is an ally for equality and warrior for social justice. Throughout an accomplished career in marketing that gave voice to prominent commercial brands, Judy Myers always kept a foothold in serving those without one. As a communications expert, Judy transforms corporate storytelling and content into shared experiences that engage consumers with merchandisers, buyers with sellers, and most importantly, advocates with causes. Currently, her craft results in passionate allyship for charitable and civic service. For the last decade, Judy has worked with a variety of corporate and nonprofit clients through her private consulting, J.M. Myers Marketing. Most recently, Judy has shifted her focus from big business to allyship in support of public service, social justice, and diversity, inclusion, equity, advocacy to give voice to underrepresented, vulnerable, and marginalized populations. She is a statewide deputy registrar and election judge for the greater Chicago area. She has been involved in political campaigns for local, state, and federal candidates, and also served on a citywide community service project, developing a database of resources to provide wellness aid to the elderly during the height of the COVID-19 pandemic. Additionally, Judy is active in organizations addressing social justice issues, including Courts Matter Illinois. And now I turn it back to Ed, I think, or Rose.
Yes, well, I will take the wheel for the moment, and I want to thank Sherry and Sandra for those introductions. And now let's get the show on the road. And David, over to you.
Thank you very much, Rosemary, and thank you to Illinois Indivisible and to NWSO FA and any other sponsoring organizations. And most of all, thank all of you for joining today. Hopefully, you can learn a little bit, or at least try and get some of your questions answered about courts and voting rights. At the beginning, let me say that the basic purposes of this presentation tonight are to help you understand the basic structure of the court system, especially federal courts and Supreme Court, and to how the right to vote connects to those courts. And then we'll discuss a little bit about current issues at the end, time permitting. I apologize if some of this information is a little too basic for some of you, which I know from looking at over the list of some of the names. I know many of you already know these basics, but we'll try and move through them and that material as quickly as possible. As I think Ed mentioned, if you have questions, please put them in the chat and we will leave time at the end for any questions. So these are our objectives, as we said. Let's talk about why do courts matter. So as you all know, courts oversee the laws that protect what's important to you. And without courts, we don't really have a rule of law. And we really have to resort to violence and other similar undesirable means to get what we want. You and I have the right to affect what the courts do, though, through our democratic and voting rights. We are the ultimate source of power, including the power for the courts. Basically, any kind of right that you particularly care about, we're ultimately going to result to the judicial branches to enforce that right. And that includes the most basic of all, which is the right to vote. So let's move on to the next slide, and we'll talk about the basics of the courts, and then we'll start focusing on the effort that's been made by right-wing forces over the past 40 years to try and stack those courts and make them unfair and unresponsive to the will of the majority of the people in this country. So first, let's talk a little bit answer some common questions about Illinois judges. As you know, if you voted in the last election, or you voted in any election really here in Illinois, as in most states, we vote for judges. 39 of the 50 states basically vote for their judges, and that's how most of the judges in state court systems are selected. So this imposes a duty on voters to learn something about judicial candidates if they're going to cast an intelligent vote for candidates. They need to make informed decisions, or we end up with a less than desirable judiciary. And this has been a source of some concern and I would say pessimism in the past, because sometimes the voters don't make such great decisions about voting for judges. However, I would like to point this one fact out for those of us in Illinois. There is a little bit of reason for optimism, I would say, based on the most recent election, the June primary that we held. And my optimism is based on this. There's a new site that was put up by Injustice Watch to help people gain information about judges. And Injustice Watch not only created a new site that's very good and very user-friendly and very complete in terms of the information it collects from other sites and from other sources, but Injustice Watch also made a very serious effort to get that voter guide distributed, often in hard copy, to people as they were entering the polls, which makes a big difference because that's when most people start thinking about who they're going to vote for judge. That appears to have been a fairly successful effort. And the reason I say that is because in looking at the results of the election, in my personal and biased opinion, it appears that 12 of the 13 countywide races for judges went to the candidates who appeared from the ratings organizations to be the better qualified candidates, and 9 of the 14 sub-circuit races, I would say at least, went to candidates that appeared to be better qualified. So that's reason for optimism. It appears to suggest a greater education of voters as the tools to help them get better. A couple other of the common questions are judges who are on the primary ballots also on the general election ballots. Yes, they will be, along with about 70 judges in Cook County and smaller numbers in other counties that are judges up for retention who aren't running against anyone but have to get 60% of the vote to stay on the bench. In the contested races, for the most part, those are decided in primary. The winner of the primary generally is unopposed in the general election. I think there's 1 or 2 contested races in Cook County where there will be a Democratic candidate facing off against a Republican candidate for judge, but most of those are essentially decided in the primary. So the final question, what's the path from voting on state judges to influence federal appointments for the Supreme Court and the appellate and federal district courts? And what impacts do state courts make on federal rulings? Let me make 3 quick points here. State law controls, in many cases in federal court, under what's known as diversity doctrine. State substantive law controls the rights of litigants in many, many federal cases, depending on the nature of the jurisdiction in those federal cases. So that's one way that state law is important. And the state judges who make those decisions, including the state appellate judges, are very important in that respect. State judges also sometimes have an influence on who gets considered for the federal court by the senators or the White House. All right, so let's move on now from talking about answering the general questions about Illinois judicial elections, and let's move into a more general discussion of the courts. Just cover the basics as quickly as we can. So the basics on the court, we have state courts and federal courts. What's the difference? State courts handle 90% of the litigation in this country. They are the courts of general jurisdiction. They are the courts that are going to handle your family law matters, your auto accident matters, your other tort claims where you're injured, your matters about probate and receipt of property, matters about general injunctions, and so on. So 90% of the cases in the country are handled by state court judges, which are elected, as I said. The other 10% of the cases are handled by federal judges, and these tend to include more of the high-profile cases. Federal judges, unlike state judges, are not elected. They're nominated for lifetime appointments that are voted on by U.S. senators after the president has made a recommendation to the Senate. Here are the three basic levels of the federal court, which of course we have the Supreme Court. That's 9 justices at the moment, although that has varied over time. The Supreme Court hears about 80 cases a year. That's of the 7,000 petitions for certiorari that it receives. So it's about 1% of the total cases, but that 7,000 cases is only about 1% of the total cases filed in all the federal trial courts. So you can see the Supreme Court actually hears about 0.001% of all the cases that are actually filed in the US in any given year. Below the Supreme Court, we have 13 district circuit courts. These are the intermediate federal appellate courts to whom appeals go from the federal trial courts. There are 13 circuits, 12 of them. There are 11 numbered circuits that are regional in nature. And there is another circuit in DC that hears primarily government-related appeals, and another circuit called the Federal Circuit, which hears things like appeals in patent cases, in vaccine cases, in Merit System Protection Board cases, and various other sort of miscellaneous jurisdictions. In all, there are 179 active appellate judges. There's a number beyond that are senior judges who don't regularly sit on cases. But as you can see, it's a relatively small number of appellate judges. Below that, at the trial court level, we have 94 US district courts. They're divided up into 94 regional districts. They include a total of 686 active district judgeships, but the number of judges is actually at least a third bigger than that because it includes judges designated as senior judges who don't count against that number. Let me just move on to our particular area now, the 7th Circuit. So we're in the 7th Circuit, which includes Wisconsin, Illinois, and Indiana. In the 7th Circuit, we have 11 judges on the appellate court. They hear about 2,500 cases a year. The majority of the cases they hear actually are civil cases, and most of their decisions in cases, about 2/3 of them, are not published. Only about a third are published, and only about a third of the cases actually end up in oral argument before the court. The other cases, the other 2/3 are decided by unpublished decisions and don't get oral argument. We are actually in the Northern District, which you can see is under the 7 in that map. The Northern District basically includes extreme northern Illinois and Cook County. There are 22 active judges in the Northern District of Illinois, 15 senior judges, so 37 judges in total, which is a fairly large district. We also have 13 magistrate judges in the district. In the Central District of Illinois, there are 4 active judges, 3 senior judges, and 2 or 3 magistrates. And in the Southern District of Illinois, there are 4 active judges and 1 senior judge and 3 magistrates. The 7th Circuit, as I said, also includes districts in Wisconsin and Indiana. So that's a overview of the system and the numbers involved and the number of courts and judges and so on. So why do federal courts matter? I think everybody probably on this call has a very good idea of why federal courts matter, but let me just remind you of some of the things that have come up in the last month or two. We've got reproductive rights, we've got the environment, we've got gun control, we've got racial discrimination, we've got religious freedom, and so on. Federal judges make decisions that affect all of our lives. So how do federal judges get on the bench? What are the steps by which, or the process by which that occurs? Let's sort of walk through this process. In theory, the president nominates candidates to fill vacancies in the judiciary at any level in the federal judiciary. However, in practice, the way it works is, again, I think many of you know, for district court judgeships at the trial court level, In general, the White House defers to recommendations that they receive from the senators in the same party as the president that represent the state. If neither senator is in the same party as the president, then often the president will turn to the senior member of the House delegation for recommendations. Although in some cases they still consult with the Senate candidates. In general, for district court candidates, most of the recommendations from the senators are accepted by the president and sent on to the Senate Judiciary Committee. For the appellate courts and Supreme Court, the White House tends to take the lead in deciding who is going to be nominated for those positions. And it's at that level in particular that you see the influence of groups like the Federalist Society in recent years, where the president and his in-house counsel turn to the Federalist Society and other similar groups for recommendations as to candidates to put on the courts, recommendations about people who they think are reliably dyed-in-the-wool conservatives who will decide things the way that president or the conservatives want them to. Once the president nominates them, it goes to the Senate Judiciary Committee, which does an investigation on the candidate, sends out a questionnaire, gets it back, has a hearing on the nominee, and decides whether the nominee is qualified. They then vote on the nominee in the Senate Judiciary Committee, make a recommendation to the overall Senate, and then the recommendation is voted on in the overall Senate. There used to be a considerable amount of delay incurred in making its way through the Senate Judiciary Committee and onto the Senate floor for a full vote. Those delays have been cut somewhat in recent years to speed up the process, which is a good thing when we have a democratic process and a democratic majority in the Senate and a Democratic president, and it's a bad thing if we have a Republican president and a Republican majority in the Senate. If assuming the Senate affirms the candidate, and in recent years, many of these confirmations have tended to be party line votes, surprisingly. Up until a couple decades ago, or actually, about a couple decades ago, most of these confirmations used to be much more harmonious with much larger majorities, but this has become a much more contentious issue over the past 20 years. Once the judicial candidate is confirmed by the Senate, the president signs the judge's confirmation, and the judge begins a lifetime appointment to the federal bench. So that's how people get on the bench. In the Northern District, the way it works in practice is that when we have two senators that are from the same party as the president, they tend to use a committee to vet candidates when there are openings for the federal court. That committee reviews people's backgrounds, their submissions, and makes recommendations to the senators, and then the senators typically make a decision among the finalists about who they're going to recommend to the White House. That's currently the way it works, since we have two Democratic senators and a Democratic president. The traditional process, as I said, used to allow for considerable debate, delay, which included up to 30 hours or even a filibuster of a nominee. But those rules were abandoned because the Republicans during the Obama administration were using them to basically try and block any progress on judicial nominees by the Obama administration. So the rules were changed and shortened. The majority leader can now call a vote with a limited time for debate, 2 hours on the floor of the Senate, and it only takes a simple majority to confirm a judge for a lifetime position. The filibuster can no longer be used to block judicial candidates. Okay, so how do the federal courts relate to voting rights? Again, I think many of you probably know this. Voting rights are, of course, a set of legal and constitutional protections that ensure the opportunity to vote in local, state, and federal elections. Technically, there is no individual right to vote that's actually mentioned in the body of the US Constitution. It is mentioned in a couple of the later amendments. But the right has been recognized as fundamental by the Supreme Court. Of course, the freedom to select our leaders, including our judges, is the essence of democracy. And if we don't have that, we don't really have a democracy. Now, this means that in order for the process to be fair, we also need fair, equal, and unobstructed access to the ballot so we don't have the kinds of things that went on during the Jim Crow years in the South, when essentially Black people were denied the right to vote. And as I'm sure you all remember, during the 60s, after Kennedy's assassination, President Johnson managed to get 3 important civil rights statutes passed in Congress that fundamentally strengthened civil rights. One of those 3 bills was the 1965 Voting Rights Act. And what this did is it basically empowered the federal government to enforce voting rights by monitoring what the states were doing in terms of allowing or disallowing people to vote. And one of the key ways it did that was through what's known as a pre-clearance process. The pre-clearance process meant that states that had a history of interfering with or obstructing the right to vote had to get pre-clearance anytime they made changes to their voting processes. This included voter purges, numbers of polling places, any kinds of qualifications imposed on voters, registration requirements, and so on. So it gave the federal government a very powerful tool to prevent states from obstructing people from voting. The problem is that the Roberts Supreme Court in the Shelby County decision a few years ago essentially gutted the 1965 Voting Rights Act. The Supreme Court ruled that even though the act had been, the act has a sunset provision and every 25 years or so it comes up for renewal. Even though the Senate had, the Congress in both the Senate and the House had voted overwhelmingly to renew the act, the Supreme Court said that the Congress based its decision on data that was out of date, and therefore it chose to disregard the votes by Congress reinstating, reaffirming the Voting Rights Act. That they knocked out that section that identified which states had previously acted to obstruct voters' rights, saying that that was based on data that was too outdated. And by doing so, they effectively eliminated pre-clearance because the federal government no longer could identify those states where it had the right to come in and require pre-clearance of any changes in the voting procedures. That effectively gutted much of the 1965 Voting Rights Act. There is still a provision that allows the federal government to sue when the state governments interfere with people's right to vote. But the problem with that is it usually takes a long time for the litigation to make its way through the courts. And usually the decision comes long after the election in question has occurred. So it is not nearly as effective as the pre-clearance requirement had been before the Supreme Court knocked that out in the Shelby County vote. Other threats, in addition to Shelby County, that have risen over the years, of course, there have been many attempts at voter suppression laws at both the state and federal level, most notably the Jim Crow laws that existed for a long time up until the 60s in most of the South. And more recently, efforts by the Republican Party to try and suppress the vote by requiring things like voter IDs, by engaging in frequent and overbroad purges that then require people to re-register to vote. And many times they don't find out until it's too late to do so. When they go to the poll on voting day, they find out that they're not registered and they can't vote. They also do it by restricting the time for early voting, by restricting vote by mail, by restricting the times when you can register to vote so we don't have same-day registration, and myriad other ways, which we've seen throughout a number of states, particularly states with Republican-controlled legislatures in the country. And I would say the third big threat to democracy is that we've never properly addressed our campaign finance system, and it tends to give undue influence in the system to large donors, to political campaigns who then have undue influence with the politicians as a result. All of these things interfere with the notion of one person, one vote, which the Warren Supreme Court recognized as fundamental in key decisions like Baker versus Carr in the early 1960s. The problem is that the current Supreme Court does not seem to believe in that principle. The other distortion I would mention before I move on is gerrymandering, which I think you're probably all well aware of in various states, particularly this is both Democrats and Republicans that gerrymander their states to try and give their party an edge and really an unfair share of the congressional seats based on the overall vote in a state by dividing up the state in devious ways. For the record, the deviations are much worse in Republican states as a general rule. And for the record, the Supreme Court suggested starting in the 60s that it might come up with it might say that there are federal limits on how far you can go in gerrymandering, since it obviously interferes with the notion of one person, one vote. But what has happened is after several decades of saying that it was waiting for an appropriate test, someone came up with an appropriate test. That case then went up to the US Supreme Court, challenging a Wisconsin gerrymandering scheme under which politicians receiving 46% of the total votes in the state ended up with a 66% supermajority in their state legislature. And an appropriate test was presented to the Supreme Court, but at that point, the Roberts and the other four conservatives on the court decided that gerrymandering was too much of a political question for the court to get involved with, and they couldn't handle it. So they have basically declined at this point to try and do anything about eliminating or restricting gerrymandering under federal law. And that means that it's very hard to try and get them interested in enforcing the notion of one person, one vote, which gerrymandering directly challenges. I think we've covered most of what the Voting Rights Act of 1965 did. It was passed under the authority of the 15th Amendment, which was one of the three amendments passed after the Civil War. And it was, as I said, it was a very, very significant change in the relationship that allowed the federal government for the first time to actually protect people's rights to vote, particularly in states that were interested in trying to obstruct people's rights to vote, like southern states obstructing the rights of Blacks to vote. The Shelby County case, which I mentioned here, eliminated preclearance, as I said. There was another subsequent case, the Brinovich case, in which in 2021, where the court upheld two Arizona laws, narrowly interpreting Section 2 of the Voting Rights Act. That's a section that still allows the federal government to bring challenges in the courts, but there are later challenges. They can't challenge things in a preclearance way. But the court has even cut back on the scope of that section of the Voting Rights Act, again, illustrating their hostility to voting rights. These rulings together make it much more difficult for the federal government to challenge actions by states that discriminate on the basis of race, color, language minority, and other things in terms of who gets to vote and who does not get to vote. And that's basically because the US Constitution says that in the first instance, states get to decide who voters are, but Congress gets to decide who gets to vote in federal elections. So Congress can adopt broader laws as to who gets to vote in federal elections, even if the states manage to adopt more restrictive procedures. So voting rights today. Where are we? It depends on where you live. Some states have adopted more restrictive voting laws, as you know. Those tend to be the states where the Republicans control the legislature and or the governorship. Without federal regulation, states basically have unrestricted rights to get away with as much as they want to try and get away with. And over the last year, 49 states have introduced 425 bills that include provisions to restrict voting rights. They have not all been passed, obviously, and in some states, some states like Illinois, we have managed to actually liberalize and make it easier to vote rather than harder to vote. But that's a minority of states. 19 states have passed 33 laws making it harder to cast ballots. A lot of them are in the South or in the Midwest or the Mountain West. 25 states, including Illinois, have enacted 62 laws with provisions that expand voter access, like expanding the time for early voting, expanding the ways in which people can register to vote, expanding the time when they can register to vote, and allowing for automatic voter registration so that when people get a driver's license or other government ID, they're automatically registered to vote unless they opt out, and they don't have to opt in or do something like that. So in general, in Illinois, we are in a relatively good position with the state of our laws. But as I said, there's many other laws where that is, many other states where that is no longer true. So I mentioned earlier dark money. Dark money not only affects the political races by essentially buying politicians, but it also has come to affect the judicial nominations. There's a secretive donor network that has spent millions, tens of millions of dollars in building the conservative supermajority on the Supreme Court. In many cases, we don't know exactly where the money comes from because they funnel it through organizations that do not have to report who their donors are. This is a quirk of the, they take advantage of a quirk of the federal tax code combined with the fact that the Republicans have basically disabled the Federal Election Commission so that they cannot bring any law and order to this area of the political frontier. And over the years, that secretive donor network, as well as the concerted efforts of many conservative groups on the right, worked to put an extremely conservative majority on the Supreme Court. And with Donald Trump getting elected in 2016, they struck gold because, as you know, at that point, Judge Scalia had died, and the question was who would be appointed to replace him. If Hillary Clinton had been elected and there were sufficient support in the Senate, we could have put a more liberal member on the Supreme Court, and then it would have been a 5-4 break in favor of the liberals for the first time in about 40 years. Because for the past 40 years, the Republicans have appointed the overwhelming number of justices to the US Supreme Court. But that did not happen. Donald Trump got elected. And in addition to the stolen nomination that they withheld from Obama, he also, of course, got nominations as a result of Anthony Kennedy's retirement, which the Republicans urged, and with the untimely death of Ruth Bader Ginsburg. That allowed them to create the current Supreme Court majority, that's 6-3, of a very radical Supreme Court. If you're interested more in the dark money stuff, I would recommend to you start by reading Republic Lost by Larry Lessig or Dark Money by Jane Mayer. That would basically get you considerable insight into this topic. Well, let's move on now to the value of voting on judges. So as I mentioned, we don't get to vote on federal judges, only very, very indirectly in the sense that we vote for our senators and we vote for the president. But we do get to vote for our state court judges, as I mentioned earlier, and it's important that we make informed votes for that. But what we do have is we do have many vacancies that occur at the federal level. And while we have at least a theoretical majority in the Senate, even if not a practical majority, and we have the presidency, it's important that we fill those judicial nominations as quickly as possible. Right now, there are about 120 federal vacancies on the federal court, that's considerable when you consider that we have only 600, well, roughly 700 active judgeships, or 1,200 if you include the appellate courts. So you can see that we've got roughly 10% at least of the courts vacant, and it would be nice to fill those vacancies with people that we think will be fairer judges, rather than putting federal society supported so-called conservatives into those federal vacancies. All right, why do federal courts matter to federal voting rights? Obviously, I think you know, as I mentioned earlier, the federal government, after the 1965 Voting Rights Act, played a very active role in making sure that people's rights to vote in elections was not interfered with the way it had been in prior decades. That is now all at risk because of the decisions by the Supreme Court in Shelby County and Brinovich. And so voting rights are now, it's open season on them in some states. As I mentioned, the Supreme Court does not actually hear many cases. It hears about 1% of the cases that are appealed to it, and the cases that are appealed to it are only about 1% of the total cases filed in the federal courts overall. So it hears about 0.001% of the overall cases. Most of the cases are decided in the circuit courts. As you can see, there's about probably 12% of cases decided in the circuit court, 12 to 15%, and then the rest are decided in first instance, and in many cases as a final matter, in the federal trial courts. So the judges who are appointed to those trial courts and appellate courts matter greatly in deciding how these cases are actually decided and how fairly they are decided, even if the Supreme Court majority is misguided. What matters on the federal courts, one thing that matters is diversity. Historically, we have not had very diverse courts. Now, there has been a concerted effort made to try and improve the situation so that we have a better reflection of the gender, ethnic, sexual orientation, and racial makeup of the nation reflected in the federal judiciary. That effort was undertaken to some extent by Bill Clinton, and even more so by Obama, and now by the Biden administration. They've made considerable progress, but we need to work on filling these remaining vacancies before the next midterm election, when, if the Republicans take control of the Senate, they will slow down or block as many judicial nominations as they can. Many of the judges who've been historically the candidates for appointment have lacked somewhat diverse experience. Many of them came from large corporate law firms or business law firms, and you had only a small number that came from places like public interest organizations, public defenders, or people whose practices were dependent on representing small individuals. That has improved somewhat under some of the Democratic administrations in recent years, but it's still an issue. This is a chart that shows that in virtually, if you look at any category, basically white males are overrepresented on the federal courts and everybody else is underrepresented. As I said, we've made considerable progress under some of the Democratic administrations, but there still is a ways to go, as you can see from these numbers on the chart. What diversity does not look like is the appointments that Donald Trump made while he was in office for 4 years. He appointed 229 lifetime appointments to the federal bench. Most of those appointments came from corporate law, and as you can see from the accompanying pie chart, the vast majority of them were white men. So, what can we do?
Thank you, David. I'll jump in here. And we know that this slide is very, very familiar to everybody on this call. So let's let it serve as a reminder for how we can get the message out to others in our communities, in our networks, with our friends and families. Knowledge is power, and we know as advocates and activists that what we do with that information is what really matters and what can really make change. So again, pay attention, raise awareness, use social media. thanks to Truth Brigade and other activities. Submit an op-ed letter to the editor about the importance of federal courts and judicial diversity, especially now. Call senators, we all know that drill. Educate others on the importance of courts, and connect it to your ongoing work every day. And always remember to vote. I mean, I think everybody on this call is probably a registered voter and exercises that right. My presentation is a little wonky. Okay, so taking action, there's so many ways to take action, and I know everyone here is probably in the throes of you know, doing campaigns and doing advocacy work on a variety of fronts. So Rose and I pulled together a couple of things that are going on right now. The Illinois Supreme Court is on the forefront of many advocates. Along with all state courts, it's the final arbitrator of our civil rights. And collectively, these state courts have the outsized impact on our constitutional rights, hearing 100 million cases across the country each year. So to that end, like myself, I signed up on to the Indivisible Evanston postcard campaign for Illinois Supreme Court race. In fact, I have enlisted several of my own network, and we've written 200 postcards to Illinois voters, encouraging them, reminding them to vote and to do due diligence when the elections come for the Illinois Supreme Court judges. There's also a resource, Jane's Army, which in Illinois advocates for reproductive rights. And as many of you probably know, that is currently under threat with the open seats on the Illinois Supreme Court. Courts Matter Illinois, we currently have a sign-on letter campaign going where we're urging Senator Durbin to work swiftly with the administration in filling the judicial vacancies with diverse qualified judges for the appellate and circuit courts. And we need to make that happen for the midterm elections. If anybody on this call is interested in learning more about that, just send an inquiry to courtsmatterillinois@gmail.com or to myself at judymyers@ameritech.net. And we can put this information in the chat, and as a follow-up to this session, we'll provide this slide. Again, we want to remind everybody that there's many resources available for you and all voters to enter the polls with knowledge and due diligence on judges to make the informed choices. There's also another really good resource called the Alliance for Justice State Court Justice Project, and it's a hub of information, data, and resources to help in choosing state Supreme Court justices. And we invite you on behalf of Courts Matter Illinois to stay connected with us. There are many ways to do that on social media, and you can sign up for our weekly Courts Matter email updates at courtsmatterillinois@gmail.com, where we'd love to add everybody to our listserv there, and to engage with us on all of our social media platforms. And we encourage you to use hashtags We Dissent, Courts, Judicial, Law, Courts Matter. That's what's going to help amplify all of our messaging and spread the word.
Thank you, Judy. I'd like to take 5 minutes now and just add a few additional points and discuss some of the recent developments at the Supreme Court, if I could. So the first point that you made about the Illinois Supreme Court, as most people on this call probably know, the Illinois Supreme Court is balanced between Democrats and Republicans. At the moment, the Democrats hold a 4-3 advantage on the Illinois Supreme Court. That's important for many rights, including reproductive rights, that we keep that advantage, but that whether or not we keep that advantage is going to be determined by elections in the newly created 2nd and 3rd judicial districts in the northwestern and central part of the state. So it's very important that we reach out to voters in those judicial districts and explain to them the importance of casting their votes in an intelligent way for the Democratic candidates who are much more pro-choice and enlightened than the Republican candidates who are going to be running for the Supreme Court, Illinois Supreme Court positions. The second thing I'd like to mention is, in addition to the places that we mentioned about making informed choices, I'd like to mention again that the Injustice Watch website is an excellent source. It's a recently created source, but it's an excellent source and probably the best source for getting information about state judicial elections. The voteforjudges.org site has traditionally been one of the best collection sites, but the Injustice Watch site has a updated and much better user interface that makes it much simpler to go through and get the information about the judges. It also collects more information about the judges. Now, finally, let me just go on to discuss the recent Supreme Court decisions over the past several months and actually over the past several years. For those who can't see it, the t-shirt I'm wearing says Supreme Court overturns right versus wrong. I think that's a feeling of a lot of us as to what's been going on in the Supreme Court, certainly in the past several months, but actually in the past several years at a minimum. The important things to remember, in my view, are these. First, it's important that we not lose hope. You should remember that anything the Supreme Court does can theoretically be overturned in some manner. In many cases, what the Supreme Court does is not the final word on a subject. In many cases, Congress can come back and can change what the Supreme Court does. For instance, majorities in Congress could pass statutes basically enshrining Roe versus Wade as the law of the land. Now, that might be challenged again in the Supreme Court, but I think it would probably withstand that challenge and would probably stand up as good law. So Supreme Court, when the Supreme Court rules, Congress can, in many cases, overrule it by adopting new laws. The same thing was true with what the Supreme Court did to the Voting Rights Act. Congress could, if it could get its act together, repass the Voting Rights Act and reinstitute the things that were originally adopted in 1965 and which worked so well between 1965 and 2015. Congress could also adopt laws that overturn some of the other courts' decisions, such as the court's decision, which is a very radical decision in the EPA case, where the court said it was going to assume for itself that agencies have to demonstrate with much more specificity that they have the power to do those things that they were created to do. That decision can be easily overruled by a declaration by Congress that, yes, that's what we want those agencies to do. So in many ways, the distressing decisions by the Supreme Court in the past several months, many of them are subject to overruling just by congressional action. Some of them would require constitutional amendments, but not most of them. And in many cases, what the court has done with respect to its misinterpretations of the Constitution, in many cases that could be changed or restricted by congressional action, even without a constitutional amendment. Even though to overrule the Supreme Court entirely, it would take a constitutional amendment. But that's doable. It's been done in the past. It's been done 27 times in our history. It's doable again if we have enough political will and support and public momentum. We can do that. Remember, that's how women got the vote eventually. That's how Blacks got the vote eventually after a civil war. And it can be done again to change bad Supreme Court decisions on the Constitution. So that's the main message I wanted to give to you is we still have the power, at least until the Supreme Court rules next term that state legislatures don't have to abide by the results of elections. We still have the power ultimately to see that this country adopts rules that we believe are fair and just. And we don't have to rely on the views of 6 misguided individuals on the Supreme Court. What else can be done with respect to the Supreme Court? There are a couple of things I want to just briefly address. And those options are the following. Number one, we could expand the size of the court to try and compensate for some of the in our view, cheating by the Republicans to see some nominations that really should have been made by Democratic presidents. We could expand the size of the court. This is similar to what Roosevelt proposed with the court packing scheme in the 1930s, which failed. And it probably is a very difficult sell politically, but it is possible. Congress sets the number of judges on the Supreme Court, and there is no set number in the Constitution, and the number of Supreme Court justices has varied over time. Congress has changed it. So that is one possibility. But as I say, I think politically, that's a very, very difficult road to hoe. Another thing we could do is impose term limits, basically, or mandatory retirement ages on Supreme Court justices. This is something that is done basically for every Supreme Court in every country other than the United States. This is the way it works. They either have, they serve for a set number of years, a term, say an 18-year term, non-renewable, or they are required to retire when they reach 65 or 70 years. We are the only country that does not have that type of a limitation. And what this results in is it results in an undue concentration of power in those individuals who sit on the Supreme Court for unduly lengthy terms for 30 and 40 years. That did not used to be the case. The average time that people spent on the Supreme Court used to be in the 17 to 18-year range. However, in the past 30 years, it has changed, and it's now gone up to an average of 25 years. And that's deceiving because it's an average. Actually, people are spending 30 to 40 years on the court because they're being appointed so young. So the system is not working the way it was originally envisioned. And we need to consider changes like term limits or mandatory retirement ages. Whether those could be done by statute or whether they would require a constitutional amendment is a subject of debate in the legal community. If you want more information on that, there was a presidential commission report that was issued in last December, looking at the possibilities of reforming the Supreme Court in these ways. A third way that the Supreme Court could be reformed would be to limit its jurisdiction. Congress has the right to limit the jurisdiction of the court. It's to the kinds of cases it is entitled to hear. This could be used to take some issues away from the court that we want, that we're not happy with the direction the court is going. So that's a third alternative for addressing an undue reach for the Supreme Court at the present time. With those comments, I think I will end my comments and turn it over to people for questions from the chat session.
And if I could just jump in to thank you, David. Thank you, Judith. Judith, thank you for putting the deck together. Thanks for the action plan, so critically important. David, thank you for going through such a rich and comprehensive material so clearly. I definitely feel a lot smarter, and I hope everybody else in the audience does too. I am very fortunate because I am part of the steering committee for Courts Matter Illinois myself, so I get to see David and Judy at least several times a month. And I hope that you will come back because this is really deep information. And we had about 150, I think, signed up. And we will be following up with everyone. It's just critically important that all of us are educated on this material. I'll be really brief, just a couple of things before we go to Q&A and attendees. There's some really, really great questions in here. So we did leave some time. But I was shared an article from one of my colleagues, Terry Marr, a New York Times article that I shared with some of the co-hosts this evening. And it was about some of which some of you are talking about in the chat, the dark money going into the state courts. I woke up a little worried about the Illinois Supreme Court, and then I read that. In my opinion, I think we're going to get a lot of dark money coming into Illinois, especially after reading that New York Times article. And we have to be ready for it, because as we're all very well aware, Illinois is a sanctuary city for reproductive rights. And I know that the opposition is looking at curtailing the ability for women to come into our state. So lots going on. And again, my thanks to David and Judith. I am now going to turn it over to Ed to start with the questions.
Thank you. I'm going to take the liberty of asking my own question first. I'm interested, David, to hear you say that we may be able to implement term limits or age limits on the Supreme Court. The Constitution states that justices shall hold their offices during good behavior. I'm curious, what is the legal interpretation that thinks that we can do this without a constitutional amendment?
Well, good behavior is a fairly amorphous term, so it's never really been conclusively defined, although it's been accepted sort of as a matter of common wisdom that it means lifetime appointment. That's true, but for instance, in the trial courts and in the appellate courts, judges serve until they take senior status. Now, that's a voluntary act, but most judges, when they get up into their late 60s and 70s, take senior status. What that means is they still get paid, so they don't have to worry about their future. They still continue to get paid, but they can take as much or as small a caseload as they want after that, and it opens up another slot for a younger judge to come onto the bench. So those senior positions do not count against the active judgeships. We could do something similar with the Supreme Court. Now, as I said, my recollection is that those statuses, taking senior status, is a voluntary act by those by judges at the trial and appellate court level. I don't know whether it could be mandatorily imposed upon the Supreme Court. That would certainly raise an interesting question. If you want to see some of the arguments back and forth about whether it can be done by statute or has to be done by constitutional amendment, there's a section in the Presidential Commission report from December of 2012 which discusses that issue.
That's great.
We will also be discussing that issue. The American Constitution Society and Federal Society are getting together to have a series of debates, about one every 2 months. And the first of those, which is going to be virtual, will be July 22nd, and will be on the question of whether or not US Supreme Court justices should be limited to an 18-year non-renewable term. Professor Erwin Chemerinsky from the Berkeley, Dean of the Berkeley Law School, will be arguing that we should adopt that kind of system, and a Federalist Society professor from Pepperdine Law School will be arguing the opposite.
That's great. I'd be interested in links to those if you have them available. Otherwise, I can look them up myself. Links to the presidential report and links to the upcoming meetings.
So I do not have them. I do not have them in front of me, but it's very easy to find the presidential report. Just put Presidential Commission 2021, and you'll find the report. What the final report was issued in December, and it has it's a commission on basically proposed Supreme Court reforms, and it was something that Biden promised to do when he was running.
Okay, well,
and it has an extensive discussion that's several hundred pages long.
All right, so let's go to some other questions. Let's see. What is the blue slip deal in the Senate Judicial Committee?
So the blue slip used to be a Senate courtesy. It wasn't a matter of statute or even rules. It was just a custom. And the way it worked was, if the senator from the state where a judicial nomination arose from, whether a trial court or an appellate court nomination arose, the senator, if they didn't return their blue slip from the home state, they could essentially block that nomination indefinitely. That custom began to waver about 2 decades ago, and gradually it was abandoned, and it has now been totally abandoned. No one, the home state senators no longer can exercise that kind of a complete veto on a judicial nominee anymore. The Senate committee does not basically recognize that courtesy anymore.
Oh, great. Thank you very much. Here's another question. How do we help speed up the current process so that more federal judges are appointed with our current Democratic majority?
The key thing is to talk, and we are in a key state because Senator Durbin is the chairman of the Senate Judiciary Committee. He and Chuck Schumer have the power to speed those processes up. And that's basically what this Courts Matter letter that Judy referred to, that's what it asks them to do. This process, as I mentioned before, has been speeded up both in Republican and Democratic administrations in the past to try and avoid leaving too many vacancies for the incoming administration. And that's what the Democrats should do now. Of course, Republicans will try and impede those efforts, but the Democrats should not let that stand in their way, in my opinion.
Okay, thank you very much. Let's see what the next question is. Is the fact that the GOP is in favor of redistricting or eliminating rights, is that a not so tacit admission that they fear actual democracy or higher turnout, even in states where their voters are in the majority?
Well, my answer would be yes. I think that the Republican Party has turned into a party that believes in minority rule in the sense of not racial minorities, but in the sense of they believe that that white people should be able to control a vote. And they believe in entrenching themselves in power, as they've done at the Supreme Court and as they're now going to try and do in various state courts through gerrymandering the legislatures, as I mentioned, as they've done in Wisconsin and Texas and a number of other states. They don't trust the majority of the voters. That's why they try and suppress the vote. That's why they try and rig the rules so that even if you win the election, you lose the election. As it's worth pointing out that, you know, many of the Republican presidents in recent years have been elected despite the fact that they lost the popular votes. They won only because the electoral vote does not follow the results of the popular vote. And that's the way the Republicans, because they are representing a shrinking minority of the population, they're trying to entrench themselves in power and entrench that minority in power.
Thank you. Someone here is asking, are we behind in appointing judges? Should we have made more progress already?
I would say that you'll get different answers from different people on this, but I would say that Senator Durbin has done a reasonable job so far, but we need to speed up the process more. That's basically the answer on where we are.
Okay, another more minor question here is someone's asking, what's the difference between a judge and a magistrate?
The difference between a judge and a magistrate is a judge has the full judicial powers under the law. A magistrate is essentially an assistant judge. In the federal system, a magistrate judge has almost the same powers as a regular judge. But in order to try jury cases, they need the consent of the parties. That's the main difference really between magistrate judges and regular judges. Magistrate judges tend to be assigned roles in cases. They frequently handle the discovery aspects of cases, which can get very detailed and difficult to deal with. Many judges assign out the responsibility for overseeing discovery to magistrate judges. Magistrate judges typically also handle a lot of the settlement negotiations because 95% of the cases that are filed in court eventually end up being settled in some fashion or other.
Okay, well, that's the sum of the questions I have. If anybody else has any other questions, please put them in the chat. I'm going to be putting into the chat the links we put up earlier, just in case anybody came in late and didn't see the links for the various and sundry events we have available. I think Marcy has an event or two to put in as well. So I want to thank you for the information you brought to us today. It's been very informative.
Thank you for having me. I appreciate it. And if people can't find some of the things that I referred to, anybody should feel free to contact me. I'm happy to respond to anyone's questions about these things and help direct them to the resources that I mentioned.
Well, we're going to be sending out your slide deck to all the registered attendees. So they'll have your contact information, and we're going to provide the links that we can find as well. I will look for the presidential report, and I'm not sure how to find the upcoming discussion.
So the upcoming discussion has not been publicized yet because we were still finalizing the arrangements, but it will go up live. The ABA is co-sponsoring that debate, the American Bar Association, and there will be a link on their site where you can register for that event. It's free and open to the public, and it'll be a Zoom presentation.
Okay, so I'll look for the site you just mentioned, the ABA site, and we'll try and provide those links along with the slides that we're sending out so that people will have the ability to participate in that and to review the President's Commissions. I have to tell you, a lot of people.
Send you, Ed, I will try and send you as soon as we get off tonight. I will send you links to that debate site and to the Presidential Commission site.
Great, thank you very much. We can include those in what we send out to people. There's a lot of concern right now about upcoming decisions that could be coming down the pike next year and how they could affect our democracy. And I personally feel that we need to act now. We may not be able to act after the midterms.
Well, I totally agree with you, Ed. And I know that to me, there's two clear important decisions coming down the pike that have already been identified for next year's Supreme Court term that will probably come out next June. One is whether or not state legislatures are subject to control by their state courts. In other words, when it comes to election law, there's this doctrine that the Republicans have been pushing that state legislatures are free to do anything, including ignore the election results and decide who they want to declare the winner of an election. That would be the antithesis of American democracy, in my view. But we will see what a majority of the Supreme Court thinks about that. The Supreme Court is also going to review whether things like affirmative action should remain permissible under the law. So those are two big areas that we can look for in the next term of the Supreme Court. And I have to say that while I'm hopeful they won't be so crazy as to hold that state legislatures can ignore election results, I am not necessarily optimistic.
Well, there's always the political ramifications of doing that. I mean, any state legislature which ignores their voters could very well be voted out of office in the next election. But still, I think it behooves all of us to push our legislators to act, to rein in the Supreme Court before the midterm election, when we know we have the political ability, then we have the ability to do so.
I agree with you, Ed, but as a practical matter, we don't really have that ability in the Senate at the moment because of the closeness of the Senate, the even division, and the fact that several senators in the Democratic Party do not agree with that point of view.
I understand that. We would need to get Sinema and Manchin on board to overcome a filibuster in this critical area. And yet I don't think any other approach is going to be viable in the short term.
In the short term, I agree with you. It's worth trying.
Yeah. All right. So I would encourage everybody to reach out to the legislators and encourage them to push for this approach. Push for the approach of overcoming the filibuster and putting some kinds of limitations on the Supreme Court to stop them from utterly destroying our democracy through enabling state legislators to take matters into their own hands as far as federal elections are concerned. So I don't have any other questions in the chat. I mean, yes, it's clear. Yes, we need to keep the House and Senate. I think it's possible we can keep the Senate. It's kind of unlikely we can keep the House, but sure, we should try. Of course, we should try. So Rose, you have some closing comments you'd like to make? I think we're done.
I'm just grateful to everyone for being here. It's been a long fight. Some of you have been at this before that, but I've been fighting since 2015, 2016. And all of this valuable information will give us power. Knowledge is power. We've heard that before. So really, my closing remarks are to take care of yourselves. We have a longer road to pursue. So please be safe. It's a crazy world out there. Take care of yourselves first amongst all the other things that we have to do. And we will see you again soon, hopefully. Thanks for being here.
So you can, for those of you that are on the Zoom, you can make a copy of the chat. If you go down to the bottom of the chat window, there should be a spot with 3 dots there where you can make a copy of the chat. That way you'll have copies of the links that we've put in the chat and copies of the other information that's in there. I'm going to make a copy of the chat right now, which I can send out as well. So that concludes our presentation for today. We're actually 5 minutes early, which is kind of amazing for something this important. But thank you all for your time and your presence. Thank you, David, and thank you for the information you brought to us today. And we really appreciate your efforts.
Thank you, Ed, and thanks everybody for listening.
Thank you.
Okay. All right. That concludes our meeting today. Thank you all for coming. I'll be sending out the slides, the chat, and the links that David is sending to me in a day or so, once I get it all together. Good night, all.
All right.
Thank you, everyone.